Good morning. Welcome to oral argument. Clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Wednesday, September 6, 2017 at 9 a.m. Case number S226036, City of San Buenaventura, Plaintiff, Cross-Defendant and Appellant versus United Water Conservation District et al. Defendants, Cross-Complainants and Appellants. For Plaintiff, Cross-Defendant and Appellant, Mr. Michael J. Colantuono.
Ready.
For Defendants, Cross-Complainants and Appellants, Mrs. Cheryl A.R. and Mrs. Jane Ellison Usher. Case number S235412, Alexander Vasilenko et al., Plaintiffs and Appellants versus Grace Family Church, Defendant and Respondent. For Respondent, Mr. Paul A. Dolormier.
Yes, ready.
For Amiki Kira, Association of Southern California Defense Council and Association of Defense Council of Northern California and Nevada, Mr. Eric S. Burstyn. And for Appellant, Mr. Frank J. Torano. Case number is 089311, the People, Plaintiff and Respondent versus Christopher Henriquez, Defendant and Appellant. For Appellant, Mr. Oscar Babro. And Mr. Scott Kaufman.
Good morning, and we're ready.
And for Respondent, Mrs. Ronnie Dina Pomerantz.
Good morning. Thank you, Jorge. Two announcements, and the first is that we have a class of 25 international students from the University of San Francisco School of Law joining us this morning. Also in attendance with the class are visiting scholars, international scholars from China, and judges from South Korea. The group is led by Professors Julianne Cartwright-Traylor and Jeffrey Kalustian. Will the professors please raise your hands? And thank you for bringing your classes here. And the students, could you please let us know who you are with a show of hands? Thank you and welcome. Also, let the record reflect that on this case, City of San Buenaventura versus United Water Conservation District, the Honorable Joan K. Urian, Associate Justice, Court of Appeal, 4th Appellate District, Division 1, sitting assigned. And counsel, you may proceed when ready.
Good morning. Michael Colantuono appearing for the City of Ventura. It's usually helpful to start a case by articulating the rule that I intend to defend. This case requires a meta rule of decision because the Constitution gives us two competing rules of decision. How do we decide whether Prop 26 or Prop 218 governs this case? I think the Constitution gives us the answer. Prop 26 says that it applies to any levy, charge, or exaction of any kind imposed by a local government, with 7 express and some implied exceptions. So we start with, is there an exception? The obvious exception of relevance here is Prop 218, because those revenue measures governed by 218 are exempt from 26. So the way to decide this case is initially to decide whether you're dealing with a property-related fee within the meaning of Proposition 218. I think the answer to that question is yes, not because that answer was inevitable. This court could have chosen a different path when Justice Mosk was still among you, but it didn't. And given the respect that this court has for stare decisis, you should think very carefully before you choose an intellectual path that has been forsaken for more than a decade.
So, counsel, what is property-related in a nutshell from your perspective?
A property-related fee is a fee that bears on one merely because you own property, including a few property-related services which are so essential that foregoing that service is tantamount to foregoing use of the property. So water supply, trash services, and I'm missing a third, from Article 13D, Section 6C, are partially exempt from the procedures that the Constitution imposes on property-related fees. It would not have made sense to partially exempt them if they were never included in the first place. Now, you might have decided that the only water, sewer, and trash fees that are within the reach of Prop 218 were those collected on the property tax roll. That might have been a sensible choice, but you didn't make that choice. You decided in the Bighorn case to reach those water charges which are collected by a monthly bill based on metered consumption.
Can I start off by asking you why this choice of framework matters for purposes of the particular challenge that you're bringing here which concerns the manner in which the charges are calculated, the amount of the charges are calculated. In your view, is there a difference between the proportional cost requirement under Proposition 218 and the fair allocation requirement of Prop 26?
I think there is a spread between those two standards, but I think the record here is so inadequate that you could decide this case without articulating how wide that spread is. This record is fundamentally inadequate to justify this fee under either standard.
And how would you describe the spread?
Prop 218 tells us that a fee must be proportionate to the cost of serving the parcel. That can't mean what it says. San Diego has 250,000 water customers. They can't do 250,000 rate makings. So Griffith helpfully tells us you can establish rationally drawn classes of customers who receive service in a way that their costs are logically the same and do class-by-class rate making. But you do have to do class-by-class rate making, and each class has to be balanced on its own costs and revenues. Prop 26 consciously copies the standard this court articulated in the SDG&E case from the Fourth, but also in St. Clair Paint. And that standard is more generous and looks to the program as a whole. Now, 26 doesn't merely codify St. Clair Paint. There was no need to do that. A lot of money was spent to pass a measure to change St. Clair Paint. But St. Clair Paint is not changed in the last paragraph of Prop 26, which articulates this standard. It's changed in the language of the exceptions. So if we were to view this as a case involving a fee for a service or a benefit under Prop 26, you'd have to show that it was a service provided directly to the payor, that there were no what I call free riders, no beneficiaries of the service who are not charged. And those requirements of direct service and no free riders were intended to change the result in St. Clair Paint, where you were charging paint manufacturers to provide health care to children who ate paint chips.
And there's also, of course, a centerpiece of your briefing is the fair allocation requirement, that there be a reasonable relationship between the cost to the payor and the benefits that the payor receives or the burdens that the payor imposes on a particular service or benefit provided by the government.
That's right.
In your view, how does that allocation requirement compare to the proportionality requirement under Prop 218?
There are obviously parallel inquiries, and many rate makers will engage in exactly the same analysis to satisfy both of them. But I think there is a shade of difference there, that 218 is somewhat more demanding than 26, because 26 harkens back to a set of cases that this court and other courts decided that allowed more freedom to allocate costs. Now, a case where you may actually need to look more closely at the standard is a case on your docket involving the State Water Resources Control Board, where they had 8 programs funded under one fee, and you're going to have to decide, is one fee for 8 programs constitutionally sufficient? And how do you tell, as a constitutional court, what one program is and what 2 programs are? That kind of line drawing exercise really is required in the Water Resources Board case. Here, the record's fundamentally inadequate. The reason it's the fundamentally inadequate is they took the Zone A charge and called it general fund discretionary money, commingled it with other discretionary services, and rendered their books incapable of proving what the Constitution demands that they prove. They can't show that the Zone A charge is not higher than the cost of the services provided, because it goes into a bucket with a bunch of other things and funds more than what the Zone A charge was imposed for. They can't show that they're not using the Zone A fee for unrelated purposes because it's in their general fund. They can't show that it's reasonably related to the cost of serving any particular customer because of the commingling. This record is fundamentally inadequate. It is so inadequate that it gives you the option, should you choose it, not to get very far into this distinction between 26 and 218.
Did the Court of Appeal address the reasonable relationship requirement in its opinion?
The Court of Appeal applied half of Prop 26. They said, if you show that your fee collects the cost of the program in toto, we're done. We don't need to examine the allocation between fee payors. With respect to the Court of Appeal, that's just wrong. That's not what the Constitution says. If that's what the Constitution says, there would have been no need to adopt Prop 26, because that's suspiciously like what St. Clair Paint said. And a lot of money and effort was spent to change St. Clair Paint in some way. I'm not sure you need to answer entirely today in every way that it was changed, but it was certainly changed in some way. And there's a 2-prong test, and you don't pass go and collect $200 if you only analyze the first prong.
So if there's, as you say, a spread between the relevant standard about the calculation of the amount of the charge under Prop 218 and Prop 26. The trial court's findings here were based solely on Prop 218. Would those findings alone be sufficient in your view to satisfy the inquiry under Prop 26? And if yes, why?
No. And the reason I say no is that I'm quite concerned about the standard of review and the mechanics of review. And the reason that I'm concerned about the standard of review and the mechanics of review is that it goes to the role of courts and legislators in our system. You've been asked to do something very peculiar, something that no administrative law professor, and I think we have two of them with us, would ever appreciate, which is apply independent judgment review to legislation. Independently judge pure choices of discretion among principles. Your business is applying principles that have other sources. How do we make sense of this? First of all, I don't think an appellate court gives deference to a trial court on a record that is developed where they're construing a cold record. You have the same institutional competency, and in my view, greater competency because of your resources of time and talent that busy trial courts don't have to penetrate the record. So let's start with what the trial court's job was. The trial court's job was to confer some deference on the legislative findings under Fukuda, but not absolute deference. And I think Judge Anderle, who I deeply respect, worked hard and wrote some brilliant opinions here, gave too much respect to a fundamentally inadequate record. Let's talk about the Zone A versus Zone B problem. Zone A is district-wide. Zone B is just the Freeman Diversion Dam. Zone B is the downstream portion of the district that benefits from the recharge that the dam makes possible. So this district has decided legislatively that there's a difference between Zone A and Zone B. But they weren't consistent about it, and they took many programs that benefit Zone B and charged them out of Zone A. That is the kind of choice that the trial court should not have deferred to because it's illogical. And certainly this court need not defer to the trial court when it makes that kind of a judgment.
Can I go back, counsel, to the prior step about what is property related?
Please.
218. So our decisions in this area are difficult to decipher, to say the least. But doesn't this case differ from Bighorn, at least insofar as that case involved ongoing water supply to particular properties, and there was not a kind of traceability problem that inheres here, which is that the service being provided is the recharging of the groundwater basins, and it's multiple basins, right? And so as the Court of Appeal reasoned, I think, here, that it's very difficult. There's a traceability problem between what is the nature of the service that's being provided and who benefits to and to what degree. So the line that can be drawn between the service provided and the property benefited is not as clear here as in Bighorn.
It is nice and simple to apply these rules to an urban piped water system. If you're not connected to the system, you're not benefiting the fees on the services of those who do. But the Constitution speaks about water and sewer, also pipes, and trash. There's no nifty little connection of trash. Think about the Farm Bureau case, which involved a fee collected on the property tax roll to recover the cost of operating the county landfill that protected farmers from having their fields used as de facto landfills and made sure that we socialized and collectivized the solution. That fee, I think, is within the reach of Prop 218 because it's on the property tax roll, you pay it because you own property, and it provides a service that's directly related to property ownership. So the nice distinction you want to make based on pipes doesn't work for trash. So I think you need a little more flexibility. And I think the 6th District persuasively tells you why you should reach this fee. And the reason for it is not least stare decisis in the fact that every major groundwater agency has been sued over the last 15 years. And every one of them has had a decision handed down or a settlement built around Prop 218. And the legislature passed the Sustainable Groundwater Management Act, called SGMA, and said service charges that produce water are subject to 218. Regulatory charges that produce regulation and reduce demand to the available natural supply are not. That's a legislative characterization of the Constitution, in my view, that is subject to some deference here under Green. So you could go a path that the court didn't take in Bighorn and that the 6th District didn't take in Amrine. But you would be disrupting an awful lot of law and an awful lot of decision-making made around the state. And to what end? You get out of the Prop 218 frying pan into the Prop 26 fire and end up with this slightly different standard of review to develop. And you end up, I think, in the same place, affirming because this record is so inadequate.
Although there are other differences besides the cost allocation requirements between the two constitutional schemes, are there not?
The primary difference is the procedural mechanism of Prop 218, and 26 has none at all. So in the 26 world, all it says is what the standards are, processes provided by substantive law that governs any particular fee. So one of the points I would make is that this mechanical question, what does the legislator do? What does the trial court do? What does the appellate court do? Who bears the burden to produce a record? That's been true since Prop 13, the agency does. Is there a duty to make a prima facie case by a plaintiff to tell the court what the issues are? Or does the respondent have to show up and brief everything? And once they've made a prima facie case, that's what's necessary to trigger our burden of proof. These mechanical issues are quite nicely laid out in a decision of the 6th District called Great Oaks. But you granted review prior to July 1 of last year and therefore depublished that decision. I made a request on behalf of some clients that you republish that decision, and that request remains pending before this court. So as you consider wrestling with the standard of review, mechanics of review conundrum, I would counsel you, bench and bar need guidance. The 6th District did a pretty good job of it, and you could do a good for the law of California without getting into the weeds on that issue yourself, simply by republishing Great Oaks.
Speaking of guidance, counsel, we can come back to Prop 26 and Prop 218, but let me ask about Prop 26 and Prop 218 in a different way and ask you to tell us whether you think that Water Code 75594 is constitutional.
You have a choice. Either it's unconstitutional or it's not. That's a binary question. But here's what happened if it is constitutional. This agency, a creature of statute, which has no police power, it has no power under Article 11, Section 9 to provide utilities. It's a creature of statute. It has only the power that's expressed or reasonably implied from its formative act. That's all they have. If they only have the power to charge for water supply, when their record so happens to produce a ratio of rates on M&I to Ag in the 3-to-1 to 5-to-1 window, this record shows most of the time they have no authority to charge a rate. Now, there might be a scenario in which they can buy down to that window with discretionary resources, but they don't have very many, and you can tell that because they had to put Zone A into the discretionary fund to cover some things. So on this record, both records, and quite frankly, any conceivable record, this agency has no power to do the very thing it was created on an urgency basis to do in 1966. And my opponent...
Not facially unconstitutional.
There's a nuance there that I'm not sure I'm prepared to pursue with you. But let me think about it this way. The legislature said in Water Code Section 74001 that the statute should be broadly construed to achieve its purpose. The purpose here was to keep Ventura's groundwater basin from running dry to the detriment of everyone and every critter that, to quote a recent Supreme Court opinion, that depends upon it. They wanted to do something, and they could not have foreseen in 1966, when I was 5, that the Constitution was going to be amended in these ways. So your choice is to figure out, how do you best serve this messy law that you've got? Do you allow this statute to stand, disable this agency and others like it, and hope the legislature will fix it eventually? Or do you do what it seems the legislature intended, which is to give this agency as much power as they could to solve the problem they wanted to solve? Personally, I think it's better for our legal system if we strike that statute down. Judge Anderley, who's crafty about standards of review, avoided deciding on a basis that would set him up for reversal. And so I think he sidestepped it. But I'm not sure he did it in an entirely intellectually satisfactory way. I think that's the best answer I have for you.
Does it matter whether we're looking at this question through a Prop 218 lens versus a Prop 26 lens? Where's the allocation requirements under Prop 218 are just across the board requirements. Under Prop 26, there's no requirement. There's nothing that says that a particular fee or charge is unconstitutional if it doesn't satisfy the fair allocation requirements, just a tax, and so it requires voter approval. How does that principle square with, or how does it relate to this question of the constitutionality of the 3-to-1 to 5-to-1 ratio prescribed by the Water Code?
We would like to think there's a distinction between saying it's a tax and it's not unconstitutional, but there never is. The reason that there never is these cases come to you having been adopted without voter approval, and therefore, if it's a tax, it's unconstitutional.
But I think the question would be for the district going forward, what is it supposed to do? Is it supposed to sort of begin by proposing charges that are based on the 3-to-1 ratio and seek voter approval, or is it to be freed from that requirement altogether?
They begin by defining the program they want to provide. That's a legislative choice within a range of discretion. And by determining the reasonable cost to provide that service. And then they allocate those costs among their customers in a fair and rational way. That's the process. What am I doing? What does it cost? How do I spread? And then they discover, am I in the 3-to-1 to 5-to-1 range or am I not? My sense is they never will be. They certainly aren't on either of these records. And they haven't suggested to you in 2 years of briefing this to 3 courts what evidence they could produce that would show it. And think about it. How is it differ if you're growing acres of tomatoes from when you're growing a plot in your backyard? The M&I class includes backyard gardeners. It includes golf courses. It includes nurseries. And you've got farmers who grow tomatoes, actually berries mostly in this marketplace. It's the same function. It responds to the groundwater table in the same way. It uses water in the same way for substantially similar purposes. Now, it's true, the M&I class also produces a lot of flow to the wastewater treatment plant and out to the ocean, and farmers don't do that so much, but they do some, because they drain wetlands in order to make the land productive. So there are differences here, but not so many as you might think. And therefore, unless they get really, really lucky or really, really creative, they're not going to land in that sweet spot. Why? These numbers were chosen politically in 1966 to give farmers a break because it was viewed as necessary. And I'm not trying to chase farmers out of Ventura County. I'm trying to make sure they pay their fair share and that the constituents of the city that I serve don't pay more than they're required to. So I think you end up in a place where they have no authority at all. They don't have the statutory authority to tax. They couldn't put a tax on the ballot and say, voters, please approve it, unless what you say is it's not a tax in the traditional sense. They have the power to do this. The Constitution says the way they do this is to put it on the ballot. But if you do that, there's some sense there, you're going to end up with a lot of mechanical questions that are unanswered.
So in your estimation, counsel, what would have been a legally valid way for the district to get as close as possible to what you take to be its goal?
There are 2 tools available to the district. One is that fairness is a range, not a point. So when you fairly allocate costs, you go as close to the farmers as you can get without getting chalk on your toes. Secondly, you use discretionary revenues to underwrite the favored class, and they have some. And thirdly, maybe you appeal to the legislature or the voters. If the voters want to subsidize a green belt around Ventura so that Ventura doesn't start to look like Orange County, and I suspect they do, that's why I had the SOAR initiative, the voters might very well tax themselves to pay for the privilege. But government can't decide to do it. And to put a fine point on it, a board dominated by farmers can't decide to do it at the expense of non-farmers, which is what's really going on here. That's why this agency has a hard time being intellectually honest and consistent about allocating Zone A to Zone B, because anything that goes in Zone A is other people's money. Anything in Zone B is farmers' money, and they know it.
So can I ask you to clarify that answer? So you're saying in order for the Water Conservation District to meet its legislative mandate to maintain and repair these aquifers and this diminishing groundwater, they have to either use discretionary funding, that is, go to the legislature and ask for additional funding to augment its water conservation budget for this purpose, or put it to a vote? And how do you do that?
Not my answer at all. He said, if I want to favor farmers, how do I do it?
I don't want to know how you favor
If you
farmers.
just want to cover your...
I want to know how do you
Yeah.
fulfill the mandate of the Water Conservation Districts when property revenues have diminished?
Every one of these constitutional provisions, 13, 26, 62, 218, and a proposition to be named later, all of them allow you to recover all of your costs. You can cover every last cost. Griffith says very plainly, one of the issues in Griffith, although it's not apparent on the face of the opinion, is they tried to run a line over the mountains into the Central Valley to deliver water. It didn't work. They'd spent tens of millions of dollars and then abandoned it. And they recovered that stranded debt from the current fee for future services. And the Griffith Court said, not a problem. You're not constitutionally entitled to perfect water service, perfectly efficient water service. You're entitled to reasonably efficient water service, and you're entitled to pay for what you get for it. You can recover every last penny of your costs. The question is, how do you allocate? You cannot recover every last penny of your costs at the expense of a disfavored customer class without a rational basis to show that they're paying no more than their fair share. That's the issue. It's not how big the pie is, it's how you slice it.
So in how you slice it, you're saying it has to be sliced under 218.
Well, I think 218 provides the answer because it's really disruptive to the law to say 26. But even if it's 26, you still have the proportionality test and the no free rider test.
So it's not impossible, but you acknowledge it'll be quite difficult in a situation when we're dealing with groundwater and interconnected basins, which makes it really difficult to try to say this fee comes from, this water comes from this basin and therefore belongs to this parcel.
Here's where I think a court stands on that issue. These are record cases. Legislatures make choices about how to structure programs and fees. And provided they act responsibly and reasonably and logically in light of their record, they can do what they want. So in the Pajaro case, we had evidence that everything seaward of the San Andreas Fault is a common pool. And therefore, they had a flat rate for everybody who got non-delivered water, meaning water through the groundwater table, and a supplemental rate for people who got piped water. Those are completely rational decisions. This agency only decided after they lost in the trial court that they had a common pool. They made up a common pool when there is years and years and years of hydrogeology showing 8 distinct basins. There's this lovely chart in something they call their rate study, which demonstrates the Mound Basin gets no benefit from water that's released from Lake Piru.
But it would make a difference if there were a common pool.
Correct. And if they had a satisfactory record basis, you would have some obligation under Fukuda, and the trial court would, to defer to those findings. But when there's no evidence in the record, you say there's no evidence in the record, and we don't. I'll give you an example. It's very common to operate a dam, to impound water and then deliver it. And you can't operate a dam without a FERC license. And you can't get a Federal Energy Regulatory Commission. And you can't get a FERC license without recreational benefits. So I'm perfectly prepared to concede that the recreation concession at Lake Piru is a proper cost of water service to Ventura on an appropriate record. But this is not that record. There's no mention of a FERC license here. There's no mention of why they chose to run a concession at Lake Piru. So I would hate to see a decision from this court say that these concessions are general benefit because they're recreation. I would much prefer to see an opinion from this court that says this record doesn't sustain it. Another record might. That's the problem for them, is they can't.
Can I return you, counsel, to the first part of the discussion and get a more more general answer about what are the merits of proceeding under 218 versus under 26? What is at stake, do you think? You seem to suggest that we would do more damage to the law by, in your view.
Yeah, I think there are substantial reliance interests here. There are cases involving the Water Replenishment District of Southern California, which covers the LA Basin, this agency, which covers Ventura, the Great Oaks case, which covers the Santa Clara Valley. There's a case that settled out of the 3rd District that involved the North San Juan Key Basin. And then there are other cases as well. There's been 15 years of law saying that groundwater agencies are subject to 218. If you unsettle that law, we end up having to re-examine all of these cases under Prop 26. And I'm not sure what benefit you get by it. The standard is not all that different, and you're on a record that can't survive either test.
But do you think we've concluded something that categorical? Because I understood you now to say groundwater agencies are subject to 218, and not they're subject to 218 because they are engaging in activities that are subject to 218. So do you read our precedent that categorically?
And it is too categorical to say that the agency itself is subject to 218. 218 applies to a revenue measure, not to an agency.
Correct.
But groundwater charges that are used to augment a groundwater basin and collected in the form of what's colloquially known as a pump tax are subject to 218 because the precedents say so and SGMA says so, and I don't see what justifies such a breach from stare decisis, because you end up with a Prop 26 analysis which takes you to largely the same place.
And if we were trying to generalize that principle, so they're subject to 218 because those particular levies are property related. So property related, coming back to the very first question, means what in general principle?
Amrine chose on a blank slate to treat groundwater, water delivered for domestic use via a groundwater table, the same as water delivered for domestic use via a pipe. And the reasons they did is they saw no basis in the Constitution to draw a distinction. You could argue that. They think the Constitution should have one meaning throughout California. I think that's right. And they think that operating a well so you can live in your house is tantamount to living in your house. No water, no life, no property value. And therefore, this is an essential service. Now, I don't think that means that every water service is subject to 218. Richmond tells you that a water connection fee is not. The case out of the San Diego County Water Authority versus Met, which is pending petition for review in this case, tells you that we've been applying Prop 26 to wholesale water charges. I also think there's a fair argument that may come to you in another case that when somebody's consuming a whole lot of water and therefore pays a larger rate for it, the Capistrano facts, that that's not a property-related service because you don't need to waste water to use your property. So
Mr.
I'm not
Colantano?
saying it's everything.
I just don't, I want to interrupt you only to say you'll have 2 minutes for rebuttal if
And
you
I-
care to save it.
I will reserve time. Thank you.
Good morning, Your Honor. Cheryl Orr on behalf of the United Water Conservation District and its Board of Directors. The present and future well-being and prosperity of the state depends upon the conservation of life-giving waters. These words spoken by this court in 1933 are no less prescient today. The problems of overdraft and seawater intrusion are ever more dire. The conservation of the groundwater of the state is an imperative. This court should clarify the law applicable to local agencies like the district, to whom the police powers of the state have been delegated by its Enabling Act, to allow those agencies to perform their mandate to conserve and preserve the groundwater for continued future use.
Counsel,
That
does
really
Prop
the
218 apply?
Prop 218 does not apply to these pumping charges.
Okay.
The rule of stare decisis should not be invoked to address a case that has not been decided before. The groundwater pumping charge in this particular case is governed by Prop 26. The court in Paro didn't have the benefit of Prop 26 in deciding its issues. What this court has to do is recognize that there's a progression. We have Prop 13, we have Prop 218, and now we have Prop 26. The court in Pajaro 1 and the court in Pajaro 2 and the Great Oaks case did not address the overlay of Prop 26 and what it means for the evolution of the law.
Can I ask you the same question that I posed to your friend on the other side?
Yes.
Which is, from your perspective, and given the sort of the focus of the debate in this case is on the calculation of the amount of the pumping charge, what is the difference between the fair allocation requirement under Prop 218 and the fair allocation requirement under Prop 26, in your view?
Well, I don't want to steal my colleague's thunder because she'll be addressing the issue of Prop 26, but there are more stringent requirements in terms of the cost of allocation imposed under 218, and that's why this is so important, because if you look at the decision in Richmond, the decision in Richmond stated that all water fees are not alike. You have to look at what the purpose of the water fee is, and I think that the definition of property-related service is given to us by virtue of the words contained in Prop 218 in Section 2H. It's defined as a property-related service means a public service having a direct relationship to property ownership. So in 218, the cost of service requirements are imposed upon a strict parcel-by-parcel basis. In Prop 26, you do not have the same strict parcel-by-parcel allocation. There is a more flexible allocation of costs and a more reasonable, the regulatory standard from Sinclair Paint is engrafted in the language of Prop 26. And so there is a more flexible requirement for deciding what is fair, what is reasonable, and what should be allocated under Prop 26 that is not contained in Prop 218. And I think the imprecise fit of these charges to Prop 218 is important because, as my colleague noted, the ability of a district, like a conservation district in this case, to actually apportion the benefits of their recharge activities on a parcel-by-parcel basis is not technologically feasible.
Can you tell us why? I realize that as I've read, the groundwater basins, these aquifers that are drying up, they're interrelated. So can you explain why it is the 218 property-related or property service doesn't work under the facts of interconnected groundwater basins, parcel to parcel?
Well, the services the district provide are not direct services. It's not that we're providing the water. We're not piping the water to the homeowner or a well owner that's using it. The groundwater exists. The groundwater is there. So this is not a property-related service like the delivery of water in Richmond. So the taking of the Richmond decision, I'm sorry, the taking of the Bighorn decision, I misspoke. Bighorn only decided that the water delivery service in that case was a property-related service. And the equation of the district services with the delivery of water through pipes is not a fair analogy because creation of dams, spreading grounds, recharge facilities, the hydrogeology is so complex. You don't know how the water spreads directly to each property or parcel of property. Plus, it is not each parcel or property owner who is extracting the water. The extraction facilities are the source of the tax. The extraction is on the production of groundwater from water-producing facilities registered within the district.
But on the other hand, we do know from our series of cases, including most especially Bighorn, that Prop 218 was intended to cover services that are necessary to the enjoyment of and use of property, and water is certainly such a use. And we know from Pajaro Valley that there are many areas in California where this is how people receive water for use on their property.
On this record, the majority, a substantial number of the extraction facilities are not for domestic or private use. But I think that is an important question because I think if you look at the purpose of enactment of Prop 218. Prop 218 was targeted by homeowners who were fed up with their property tax bills having these added fees and their utility bills having these added fees for services that did not directly benefit them. That was the target of Prop 218. The target of Prop 26, that was regulatory fees. But in enacting Prop 218, they were talking about things that didn't benefit them. That's why they asserted and agreed with the language that a property-related service had to have a direct relationship to property ownership.
But why wouldn't the citizens that complained and pushed for 218 have the same complaint here?
They weren't complaining about water, groundwater, or the right to groundwater. They didn't speak to that. They talked about sewer, refuse collection, and water delivery. It is much easier to say, I can allocate the cost of driving my truck down the street to pick up the sewer from an individual homeowner on this street or to pick up the waste from a farm located in another area. You can directly identify the cost to that service and attribute it to that parcel. We're talking about...
But under this fee, they're paying for the exact amount of water that they're pumping.
They're paying a fee for the exact amount of water they're pumping, but the cost of the district-wide services that the district is providing is utilized in a manner that you cannot attribute its cost on a parcel-by-parcel basis because you can't follow the water. And it's a dynamic situation. Hydrogeology changes because we're having these overdraft and long-term overdraft problems. We're having subsidence issues. So the geology is constantly changing. So that's one of the other problems with determining what recharge facilities work, where are they going. But I did want to...
Council, what about landfill maintenance? Your opponent on their side cited landfill maintenance as an example. Is that easily traced to particular parcels?
Well, I think if you could determine that the amount of trash that is brought to a landfill by someone who's delivering the landfill, you can determine, it wouldn't be determined on a parcel by parcel basis. And I'm not sure that would actually be as an incident of property ownership if you're actually going to a facility that is a specific offsite landfill. I'm not sure that you as a property owner are receiving a direct benefit from that public utility. But I think that the property ownership issue, I wanted to go back to that because I think it's very, very important that groundwater pumping here is a voluntary act of conducting an operation on the property. The fee ceases if you stop pumping. Water rights, whether they're overlying, appropriative, or prescriptive, are all usufructuary rights. The holders of those rights only have the right to use the property of another. The another, in this case, is the state. The state owns the groundwater under Water Code Section 102, and also by virtue of Article 10, Section 2, since 1928, the state is constitutionally mandated to conserve the groundwater and regulate it for all users and for the public health. So since 1928, actual groundwater rights are founded in the state as a matter of constitutional law. So with respect to 218, when you go back and you look at what did 218 intend to serve, it intended to serve the rights of people who owned their real property and the rights of people who got their utility bills to say, I'm only going to be charged for what I do on my property, not just because I own my property, and what I receive from a public utility as a benefit and not anymore. Now, the overlay is when you read Prop 218 and pari materia with Prop 226, you realize that there was a progression, that they weren't targeting regulatory fees when they enacted 218, but then they found that the use of regulatory fees and judicial interpretation of the right to impose regulatory fees created more taxes and more fees. And so then in Prop 26, they decided to target these additional fees and say that now we're going to tighten up what can be imposed as a regulatory fee, and these are the particular exceptions. And I think that the use of the, I don't want to, again, steal my colleague's thunder because she'll be talking about 26, but I believe that you need to look at that progression, and that analysis was not made in Pajaro 1, Pajaro 2, or Great Oaks.
Can I ask you to take us through an exercise briefly of if we were to determine that these groundwater pumping activities were in fact property related or a service incident to property ownership, how would the Water Conservation District go about imposing fees for this service constitutionally?
Well, we attempted to introduce in the trial court in phase 3 a cost of service analysis that did attempt to justify the 3-to-1 ratio in between the ag and M&I users, but the trial court declined to take judicial notice of that. The water districts would do what they needed to do, but they would be constrained to follow Water Code Section 75594, which dictates the 3-to-1 ratio. And if the court found that they were required to comply with Prop 218, they would have to comport with the cost of service requirement and make
Your
this.
response to your friend on the other side who says that on this record, you can't justify it.
Well, I think he's taking license with the record. I think that the trial court rejected the notion that Zone A charges were being, or Zone A funds were being used for anything but Zone A charges, and that it was appropriate to have a second Zone B fund relating to specific services in that smaller Zone B. And the findings were supported, JAE 2139 with respect to the Zone A and Zone B charges, and the court noted that the budgeting for the district confirmed that they only budgeted Zone A funds for Zone A charges. So the argument that was made in the trial court by the city that there was this commingling was rejected on the evidence that was presented in the trial court. There was no commingling of funds, and even though they denominated it a general fund, it was not a general fund, it was only used for Zone A expenditures.
So when we've talked about the constitutionality of Water Code 75594, we've talked primarily in terms of whether historical data can justify allocation of cost under Prop 218 in accordance with the 3-to-1 or 5-to-1, but here 3-to-1 ratio. But going forward, is there just sort of fundamental incompatibility between the standard that Prop 218 calls for and a directive that calls for the allocation of costs on some basis other than the proportional cost of service, if that's the framework we're operating under?
That is why I believe our court looked at the specific language of Prop 218, Section 6. My colleague indicated that the language couldn't be satisfied, so it should be more flexibly interpreted. Well, this court should actually interpret the language of 218, a constitutional provision, according to the words that are used. And this imprecision or imprecise fit and a disconnect between the groundwater pumping charge and the service that it provides to the basin and the service that it provides to extractors of providing a managed basin that provides water for continued use is not the same service as a public service, a public utility providing a property service to a real property owner.
So let's even take as a given your argument that Prop 26 is the right framework instead of Prop 218. There is still a fair allocation requirement under that constitutional provision. So how does any kind of constitutionally required fair allocation requirement comport with the 3-to-1 ratio called for under the Water Code?
Well, I believe that if you look at the qualitative as well as the quantitative benefits from agricultural use, that a district could convince a court that the 3-to-1 ratio is a fair and reasonable allocation.
What is the qualitative benefit, counsel?
Because agricultural use is used on the property and it recharges the groundwater. It percolates back into the aquifer.
That would just mean that the statute is really doing no work, right?
I'm sorry, I didn't
That
hear.
would just mean that the statute is doing no work, because the fair allocation requirement would have already justified the 3-to-1 ratio. The statute's only doing any work in situations where the fair allocation notion is not otherwise satisfied, and that the statute then has bite in those situations where 3-to-1 is being mandated over and above any kind of fair allocation. But because the fair allocation is a constitutional requirement, how could that water code stand in any situation where it does any work?
Well, I think that the allocation only, an allocation between ag and non-ag or M&I users is not incompatible with Prop 26. You can,
What would that scenario be?
because the legislature has declared that it is fair to attribute agricultural use to or subsidize agricultural use for the sake of the economy. And that legislative decision has been made, and that is a policy decision that has been made by the legislature with respect to agricultural use.
Is that a constitutional construction by the legislature of what a fair allocation is?
No, I don't think so, but I think that the words of Prop 26 give the legislature the ability to think through these qualitative differences between users to make a different allocation.
Gather
It's
what
not-
you're saying, counsel. I gather, you can tell me if you're saying something different, is that while we must ultimately give effect to constitutional provisions that call for apportionment, for example, and to weigh benefits and burdens, something about what the legislature does in the course of legislating should inform our understanding of what counts as a benefit and what counts as a burden.
That's true, because the legislature has made some type of informed decision that has not changed since 1965 or 68 when the water code was enacted, that there should be this adjustment in the water rates and this differential in the water rates to favor agricultural users.
But would you then concede at least that there would be some allocations that would involve a 3-to-1 ratio, a 4-to-1 ratio that would simply not be constitutional? In other words, even if the legislature had been taken seriously in its own gloss that it put on the notion of a benefit, there would be some instances where that would not be enough to justify the ratio.
True, but each case would stand on its own record and its own cost of benefit or cost of service analysis that is undertaken under 26, and with the overlay of 75594. In this case, we didn't have a choice. The district had to comply with that mandate, and we didn't have a constitutional, we couldn't avoid the Constitution and not apply a statute that this court has not struck down as unconstitutional.
That's something that, is there something you would have wanted to do differently?
They've been operating under the statute for, I think, something like 37 years, and it's been their guiding principle in terms of rate making. The problem is the proliferation of Prop 218 cases and challenges threatens to undermine, if not destroy, the long-term ability of these agencies to engage in rate making. They engage in rate making every year, and they're faced with these cost of service challenges under Prop 218. And the fact that Pajaro has been on the books for 8, 10 years, whatever it is, doesn't mean that it's right, and doesn't mean that these districts should be jumping through the hoops of Prop 218 when we know what the intent of Prop 218 was. There's a separate constitutional provision under Prop 26, and we can meet the exception to Prop 26 that isn't the property-related fee exception of Prop 26.
In the Sustainable Groundwater Management Act, the legislature did decide to impose the requirements of Prop 218, at least on certain groundwater management districts, didn't it?
I think the legislature did that to provide some guidance for the agencies that would be set up under SGMA because of the existing case law, because of the Pajaro line of cases, and the notion that if you have some case law out there that says that Prop 218 is governing your rate making, the legislature can't do anything about that if it's not constitutionally permissible. They can't override that decision. So what they have to do is they have to legislate, give their agencies that they're formulating some guidance of what to do. And they made two choices. You can follow Prop 26 if you're a sustainability plan, creating a sustainability plan, but if you're engaging in groundwater management, you would follow the Prop 218 path. But sustainability programs include some of the same abilities or powers to create facilities, acquire land, do all those things. So I think that there's still flexibility under SGMA for those agencies created under SGMA to engage in their rate making subject to Prop 26 and not subject to Prop 218.
Ms. Orr, your time's expired.
I'm sorry, Your Honor.
Good morning, Chief Justice, Associate Justices. Welcome, Justice Urian. My name is Jane Usher. I had intended to talk about Prop 26 and how fundamentally different it is from Prop 218. You have already asked some of those questions, and I don't want to presume that you don't have the answer.
I would still like to hear about that.
Very good. When I read the Pajaro line of cases, and I called them Pajaro 1, Pajaro 2, and Great Oaks, I was struck by the disconnect, as my colleague Cheryl Orr has mentioned, between the statutory language, the constitutional language of Proposition 218, its procedural mandates as well as its substantive mandates, and those decisions. As I read those cases, I felt like the judiciary was doing judicial backflips. There was confusion. There was speculation on the part of the court to make a Proposition 218, fit groundwater, distinct from domestic water delivered to homeowners through pipes. I felt like the court was trying to shoehorn factual circumstances that were inapposite. So we started Prop 218 with the notion set forth in Apartment Association that the action of the property, the action of the fee has to be as an incident of property ownership, which they indicate to us is by virtue of property ownership. Nothing more needs to happen and you will be charged. That isn't this case. That isn't a groundwater management case.
I mean, but we have gone beyond that.
So you're referring to Richmond and Bighorn?
Yes.
But I think Bighorn only took you to this point. I think Bighorn only took you to the point that water delivered by a public water agency for domestic purposes through pipelines is as an incident of property ownership. I don't think this court has ever looked at groundwater and groundwater management, conservation, protection, and augmentation, and equated that with the delivery of water domestically through a pipeline.
Could you clarify for me on this record, does the city operates a number of wells?
Yes, it does.
And those are not solely for domestic use, are they?
How,
Or are they not, I guess?
how the city uses it, I believe that the city uses some of the water for its own purposes, and I believe acts as if you will, as a wholesaler, as a retailer, and it sells it to its urban customers. So I think it does both.
Mm-hmm. Is there some way to figure out how much of the water is being sold or channeled to property?
I believe that would be discernible, yes.
I guess it's kind of hard. I agree with you that Bighorn is not directly, squarely on point, but it doesn't seem a huge step to say, well, okay, ongoing service to property is a form of property-related service, but the next step is just, well, what is the precondition of that?
I understand your discomfort, and here's how I think about it. When the city does whatever it does with the groundwater that it extracts, and of course, that's not United Water District's obligation to monitor or record. The city's obliged to record the water it extracts, and it is not obligated to tell United what it uses that water for, only the volume. The city then has a relationship with its customers, the urban dwellers, and that relationship and that rate setting has its own set of protections, constitutional protections. And I think what you have to do is you have to say, United has a mission, a purpose, it's groundwater preservation, augmentation, conservation. The city has a different purpose, and the city will follow the constitutional mandates of rate setting as it relates to its own customers.
So, Ms. Escher, before you run out of time,
Oh, I'm so sorry.
I understand that you're going to talk to us about Prop 26.
Yes.
So can you tell me why Prop 26 fits this kind of case of groundwater and pumping activity of the groundwater versus 218?
Very good, Your Honor. Where we find ourselves with Prop 26 is voter discontent over hidden taxes, the blurring of lines. What's a charge? What's a fee? What's a tax? They came up with what I'll call the omnibus solution. Everything is presumptively a tax unless it meets one of the 7 enumerated exceptions. We have an exception, it's E1, and it fits so appropriately the factual circumstances of what United does and the benefits and the burdens of the city. It fits like a glove. I referenced earlier the Prop 218 judicial backflips, one of which is...
So why does E fit?
Because E1 says you are not a tax if you provide a specific benefit or privilege, and you don't charge for this specific benefit more than the reasonable cost of your governmental activity. So I consider the groundwater, we've talked a little bit about how the Santa Clara River, but for the activities of United, that river water would be lost to the ocean. It would not necessarily be recharging the aquifers. That's United's job. Protect those aquifers, recharge, divert,